Hi, welcome. I'm Corey Shapiro. This is the introduction, and I want to tell you why this guide exists. First, I'm a divorce attorney in New York City. I'm also a child of divorce, and I see how people enter this divorce process in a fog. They're overwhelmed, they're reactive, and they're making decisions really on impulse. And I've created this roadmap so you don't have to stumble through that fog, and it gives you a clear structure, a way to orient yourself through this divorce process, which is really sometimes just overwhelming. So how to use this guide. This isn't Google Maps. It's not going to update. It's not a live GPS. It's rather a big picture guide, a big picture map from the driveway, which is your first decision about moving forward with a divorce, through that first major checkpoint with the court. If you can't settle, that's the preliminary conference. If you hit detours or you have some emergencies, you can always reach out to me for a free introduction call, and we can see if we are a right fit. But you can also just come back to this guide whenever you need it. Use it for reference points, not as one-time lessons. And let me just give you a general overview of this guide. We do it in 3 stages, 9 steps. The 3 stages are getting ready, getting your bearings, and moving forward. In that first stage, getting ready, the 3 steps are: you got your driveway decisions, which is, am I really doing this? Am I really moving forward for a divorce? And we're going to talk about that because the grass isn't always greener. And step 2 is choose your route. Do I have to do court, or is there non-court options like mediation and negotiation or collaborative divorce? Step 3, that's prep your car. You don't go on a big trip without prepping. So you got to learn a little bit about pre-divorce planning, the good and bad of pre-divorce planning, and the status quo. In the getting your bearings stage, we have also 3 sections. We have 4, which is choose your guide, which is the right attorney fit. And step 5, which is you got to read the dashboard. You got 3 gauges on the dashboard. You have kids, support, and property. And step 6, this is the disclosure. This is discovery. We call it check under the hood. Check under the hood. Make sure everything's okay. And in that last stage, moving forward, we got step 7. We got the difference between the local roads and the highways, which is the difference between negotiation and litigation. And don't think litigation, is faster. There can be tolls. There can be traffic jams. And in step 8, that's your emergency off-ramps. That's when you have a problem and you need help from the court. And step 9, that's a court checkpoint. If you can't settle your case, you're going to have what's called a preliminary conference. Now, let me just leave you with some thoughts about mindset, because I want you to let you know divorce isn't about winning every mile. It's about moving forward with clarity and purpose. I just want you to remember 3 things. First, kids only have one childhood, and it's your job to protect it. Money is fungible. You can always make more money, but you can't make more time. And finally, don't act on impulse. Act with intention. Think of it this way. I want you to think about divorce as paying in cash, not on credit. Meaning, you got to face these hard costs now. I don't want you to push these costs with interest and penalties possibly onto your kids or your future self. And that mindset is what's going to keep you steady when your emotions run high. All right, we're up to step 1. We're starting this journey, step 1, which is starting or resisting the divorce. This is what I call the driveway decision. When you're in the driveway and, you start the engine and you're ready to move out, or do we just stay parked in that driveway? Sometimes this road trip is long, and I appreciate not wanting to go on this trip. This is a big trip. And that's why I'm doing this step 1. And the key terms I want you to think about is the difference between a sudden start and a planned start. A sudden start, that's a surprise. That's high shock value. That's, hard to dial back. Just an immediate decision. And sometimes you have to make these immediate sudden starts if there's an emergency. If an emergency is happening, you got to get out of that driveway. But a lot of times you can do a planned start. And that's really what I'm speaking to here, where you're a little bit more calmer where you're a little bit more respectful in how you start this process, because how you start this process influences how it may end. Do you talk about the divorce maybe in couples counseling? Can you be civil? Maybe not always. And also, I'm not a therapist. I've just been doing this about 25 years as a divorce lawyer, and I've seen two major issues, or two groups of people. One, you have seasonal problems, which are issues that are not good, but they pass, or hopefully pass, like maybe a job loss, or health issues, or a life stage. They always say about the midlife crisis when they turn, say 50 or 60. But then there's also structural problems. And that's where you have these core mismatch in values. And I love that quote from Susan Lucci, that soap opera actress, who said that she was married many times to the same person. And I think what she's really saying is, we evolve in our relationships. And who you were in your 20s and 30s may be different, definitely different for me in my 40s and 50s. And you might just grow apart as they're growing together. And if you're thinking about, resisting divorce, I just want to give you the New York no-fault reality that you don't have to prove any wrongdoing. It's no fault. We've changed the laws for a while now, so it's hard to resist a divorce. And it might just make things more expensive, more complicated than it has to be. So let me give you some action steps to think this through. And just as an aside, this is a great time to be doing this because as a thought partner, you can be using AI. You don't have to talk to an expensive attorney to start or a therapist. You can flesh things out with AI, with ChatGPT, with Claude, and try it. So with these action steps, if they're overwhelming, it's not perfect. At least now it's not perfect, but it's really going to help you, I think about these issues in a better way. My wife, for example, she had to take this test. She used ChatGPT as a study partner, and she said she wouldn't have passed the test unless she used ChatGPT. So check it out. So what I'd like you to do is write 5 minutes. Could be more, but at least 5 minutes in a journal. You can do it first thing in the morning if you're like me, a morning person, or at the end of the day if you're a night person. And try it for at least 30 days, maybe up to 90 days. And just think, am I choosing this divorce or am I reacting to it? And if you're reacting to it, think about this. Think, is this issue fixable, which is more seasonal, or is it foundational? Is it structural? That's going to give you some clarity. And I also am a big believer in intentions. The reason intentions are so good is you're reprogramming your subconscious. It's really hard to reprogram your subconscious because I think it was programmed when we were very young, before we even realized it was programmed. And a lot of growing up is reprogramming things that are just automatic. So here's my intention. I want you to say this. I want this process to be, and fill in the blank for what works for you. I want this process to be easy on my kids. I want this process to be easy on my kids. And say that in the morning and the night. Just say it to yourself. Many times a day as you can, but at least I would say 5 times a day. I want this process to be easy on my kids. And that's going to influence your behavior. I became a divorce lawyer because my mom made some reactive choices that really impacted our family. She just left our family. And if she's, quieted down and had this ability just to give some thought as opposed to moving from impulse, maybe things would have been very different. But they can be different. They can't be different for me, but they can be different for you. Let me also talk about the 24-hour rule. I talk about a lot of that in my book and my podcast because I think it's such an important thing. And again, using AI as a thought partner, I came up with the 24-hour rule before, or I've been using it before AI, but I have to say it's really helpful. I will still wait to 24 hours, but you could, you get activated on an email, a text, someone's, your spouse says something, and instead of just responding, you can wait 24 hours. But here's the difference. In that 24-hour period, you can put in AI what you want to say, unedited, and then ask it to make it sound much better, much civil, much more respectful, and you can see the change. You might not be able to buy into it. Wait that 24 hours, rewrite it again, but you can see at least where it should go. think that's a great thing, the 24-hour rule. And also, think about your opening, tone when you start a divorce. Do you have to do something with high shock value? I don't know if you remember with Jason Sudeikis, where he served Olivia Wilde papers, legal papers. And I don't know if this was true or not, just seeing it like everyone else. He served legal papers in a public forum. They have kids in common. They're sharing kids. Do you have to do that? Now, maybe he had to. I don't know. But it seems aggressive. Can't you just send an email and see if they accept papers? How you start things really influences how things are going. So my big takeaway is begin with your why. Begin with the end in mind. Have those intentions that work for you. And my theory is usually start with diplomacy if you can, unless there's an emergency issue, and don't use force unless really necessary. And start these small habits. Start the journaling. Start the intention. Start that 24-hour pause. It's really going to make a big difference. And really what I'm doing here is I'm helping you. But I'm also helping your children stay out of a multi-year battle, or at least do everything you can to make that battle better than it has to be. All right, we're up to step 2. Pick your route. Now, my road trip analogy is this. There's 2, let's call them roads to get to your journey, to get to the end of the journey. There's the local roads and the interstate. And on the local roads, it's the scenic route. There's more stops. There's more flexibility. On the interstate, there's more rules. There's tolls. There's fewer exits. And I don't want you to think it's always faster. There could be bumper-to-bumper traffic on the interstate. And I also want you to think you can always switch roads. But it's very important to decide which road you're going to take. And I want you to consider the local roads as your negotiation. That's going to give you the custom that you need. And the interstate is the court. But the court doesn't go into depth sometimes. It's big issues. So it's not going to really get to where your family really, those real issues that need to be resolved. Court doesn't generally do that unless it's like an emergency issue. So let me just talk about some key terms here and think about the process spectrum or the control spectrum. And I'm going to start off with the most control you can have in your divorce, which is what I'm going to call DIY, do it yourself. Sometimes, like around this table, you could have at the kitchen table 2 spouses and they can work it out. They can be respectful. Maybe they can do a draft agreement on AI, have it reviewed by an attorney and a consultation. They're good to go. That's not really who I'm speaking to about in this guide, but that could be done. And on certain issues, we all can try to resolve certain issues that way, but not all issues. The next step up is a mediator. A lot of times mediation now is done virtually, but back in the day, it would be like this table. Let's say I'm the mediator here, one spouse is here, one spouse is here, and you need a facilitator to help them through communication. The mediator represents both of them, and they're in control of the process, but the parties are in control of all the decisions. Everything moves forward through an agreement. That's mediation. A step up is collaborative. Collaborative divorce is a little different than mediation, where you have each spouse has their own attorney, and that attorney is advocating for them. But they agree not to go to court. They don't go to court. So they're looking for a win-win solution for everyone, but they are trying to shape things to their client's benefit. But they can try to negotiate with the other side to hopefully that they'll see the light, that their position is better. And sometimes you need, in this collaborative, you can still have financial neutrals. You could have child experts. I don't want you to think it's just these 2 attorneys and the 2 parties. You can have experts, but these are people who need more support. That's collaborative. In cooperative, it's like a mixture where the attorneys, it's still an attorneys, but now these attorneys will go to court. But they're really only going to court if someone's being totally unreasonable. That's what cooperative attorneys. So they really try to work things out outside of court. They want to keep costs down. They really want to resolve things. They want to move to a win-win if they can. But if someone's being unreasonable, they didn't make that pledge not to go to court. And sometimes people need to go to court. And I've found sometimes the closer you get to court, the more reasonable people come. Sort of reminds me like when you're driving on the highway and people are going, so fast, but when people see the police, they slow down a little bit. That's like what the judge does. You slow down a little bit. Now, people who see the cops and want to keep on going, that's litigation. That's where you're enabling bad behavior. Litigators are looking for a win-lose. Okay, and you have to understand it could take years, especially in New York City, for these cases to go through the system. And it's so expensive in money, time, energy, and emotion. So you have to be very careful when you go to court, and you have to make sure these issues are big enough issues because you might just get sucked into the system. And one quick thing I want to let you know, 95% cases, I think even more, but at least 95% of cases settle. So which outcome you pick in the beginning really influences how things are going to go. Now, let me give you some action steps. And again, you can use AI as a thought partner here to make this process easier for you, to get you up to speed quicker. And if you're grieving right now, and I appreciate that, if this is really hard, because it takes up to 2 years to grieve, realize that the court doesn't wait for you. And that's why this AI really can accelerate your learning curve in your divorce. So let me give you some action steps to think about. First thing is, why don't you rate your case? Just do it on 2 scales, 1 to 10. Emotional heat versus financial complexity. Like 10 would be most heat. It's burning up. 10 would be on the financial side, financially complex. I don't want you to think just because people are toxic, that doesn't mean, that could be your 9 or 10. That can still be for mediation with a really good mediator. And just because things are financially complex doesn't mean you have to go to litigation. You just have to maybe get experts. So a person can make a lot of money, over $1 million a year. It could be W-2 income. It could be reported. It could be transparent. But if it's a little bit more complex, where their income is at, say, $100,000, at least on their tax return, but their expenses are $40,000 a month, something's not right. And that's where you have that financial complexity. I also want you to consider your control level. If you want a lot of control, you don't want to go to court because the court's going to make decisions for you. And that's the whole reason people settle, because they don't want this judge, this stranger, what they usually say, to make decisions for you. And if the other side does not want to do, a collaborative or out-of-court negotiation, a lot of people don't because it's different, try this. Give it a 90-day diplomacy window. 90 days. Ask them, will you agree for 90 days, at least 90 days, to try to resolve things out of court? See if they'll do that. Also, vet lawyers. Lawyers marketing and what they really are 2 different things. A lot of attorneys market, they do mediation, they do collaborative. They're not really collaborative attorneys. They might be litigators. You have to be very careful. So ask this question. How did you resolve your last 5 cases? If they resolved them all on the first day of trial, that's not a collaborative attorney. That's a litigator. And likewise, if the last 5 cases have been in collaborative or mediation or negotiation, that's not necessarily a litigator. So know which process you want. And this is the biggest one. You got to be very careful with triggers, with guardrails, because a lot of times people spend too much time trying to settle. And sometimes cases can't be settled without a third party, a decision maker. So if you give it 90 days to try to that diplomacy window and things haven't really moved, maybe an extra 30 days, but there comes a point where you might need a decider. Doesn't necessarily have to be a judge. Maybe it could be a private arbitration, but you're going to need a third party to help you move through things, because something what I call position polarization starts, where you just get so tight in your position, you're not going to change your mind. And that becomes problematic. All right, so my takeaway is this route you choose is so important. So important. If you want more control, start off with that diplomacy. Keep those costs visible, not just the financial costs, the emotional costs, the energy costs. Think about the children, how things are going to play out. And you can always reroute. If you start off on the negotiation on those back roads, the local roads, and things really escalate, get on that highway and, go to court. And then what the court usually does is pushes you back into negotiation. Sometimes you just need an issue or two to be resolved by court, and then everything else falls into place. And I hope that happens to you if you find yourself in court. All right, we're up to step 3, pre-divorce planning. This is plan before you file. Think of this. If you're on your road trip and you have a long road trip, which is sometimes what divorce is all about, you got to make sure if you have like a gas car like us, fill up that tank of gas. You got your snacks lined up. You have your water lined up. You have the time of day you're leaving. Are you leaving in the middle of the day with all this traffic? We go to the shore, and leaving at 11 is very different than leaving at 7 a.m. What you're trying to do is have fewer surprises. So that's what pre-divorce planning is. It's like a quiet setup. Let me give you some key terms to think about. First, the most important term, status quo. You're going to hear a lot about the status quo. That's the snapshot. That's the baseline. Whatever the family is doing is the status quo. So if you live in a house and your expenses are $10,000 a month, that's the status quo. If you have one parent who takes primarily care of the children and one parent works all the time, that's the status quo. And it's very hard to change the status quo. And that's why people do pre-divorce planning, because they're trying to change the status quo before the divorce starts, because they don't want that snapshot. So that's why you have to really think about a quiet build. Courts don't like, in negotiation, we don't like fast moves in the divorce world. So if you're making, good money, $500,000 a year, and you're like, I'm going to get a divorce in 6 months, and I'm just going to become a tennis instructor. I love tennis. I know it's only my hobby, but I'm going to do that. You can't just make $50,000 a year. The court's going to say to you, that's not how this works. And that's why I want you to understand the difference between your stated income and your earning capacity. Someone who used to make $500,000, now making $50,000, that's suspect. Unless there's a real good reason, they're going to base it on your earning capacity and not your stated earnings. You also want to consider a paper trail. A lot of people come to me and they have all these ideas of what they think they can prove in court. But unless you have the records, the information, it's really hard to prove things. Because if the other side denies it, how are you going to prove it? So you have to have a paper trail. And finally, think about your credibility. That's the most important thing in divorce. A lot of it is court doesn't know for sure, but they give you the benefit of the doubt if they believe in your credibility. And that's why how you act in the divorce is so important. It's sort of persuasion. A lot of times the court knows where it's going to go before the trial if one, party acted out during the divorce. That's why it's so important, the credibility. All right, so let me give you some action steps. And again, have your AI help you with this as a thought partner if this is too overwhelming. You can, of course, talk to a therapist. You can, of course, have an introduction call with me to talk about these things. But it might be a good idea to flesh this out with you so you won't be so anxious. It'd be easier for you. So check it out. And if you haven't used AI yet, use it. It's not so bad. It's not perfect yet, but it's really going to help you as a thought partner. So let me just go over the action steps, some things to think about. Because status quo is so important, think about a baseline. What is your family doing now? That's really important. So if you live in a nice home and the other spouse says, I think we should move homes, see if it's a similar home or if it's a much smaller home. Because remember, they're changing the status quo. If they change the health insurance, it could be as simple as health insurance. Are they reducing the plan? Why are they reducing the plan? Why are they reducing the coverage? So have that baseline. Other thing I want you to think about is keeping sort of like a parenting file. Who's going to these appointments? Who's doing what? Who's going to parent-teacher conferences? Who's doing all that? Keep that information. Very helpful if you're going to have a contested custody case. Also, you want to secure your digital life. If you're keeping some of this information, make sure you don't have shared passwords. iCloud could be a problem. I think when you send a message on your phone, it goes to your iPad, it goes to your computer. Who has access to all those devices? So if you're doing something like this, be very careful of what the other spouse has access to. I love thinking about also the objective observer test. I want you to think about a little judge on your shoulder. Think of that little judge in that little black robe. And if you're doing some of this pre-divorce planning, I want you to think of that judge saying, is this good pre-divorce planning or bad pre-divorce planning? Bad pre-divorce planning is when you're doing something to reduce the marital estate in a sudden way. So sometimes you see people, they won't deposit all their income. They put the income into these third-party accounts with other people, or they put the income into these crypto accounts, or they're just trying to move money around. And it becomes very complicated. Look at if they have a business, maybe they're retaining earnings in the business. Maybe they brought in a partner. You don't really know what's going on. That gets complicated. That's bad pre-divorce planning. The good pre-divorce planning is thinking like this. Let's say you're upstate New York and you want to move to the city and you're done in this marriage. How can you do that without having a contested relocation case? How can you do that? Well, if you think about it years in advance and you slowly get a job and you stay with your family, maybe you can, in a few years after you get that job in New York and after you've been commuting up and down, and then maybe you can slowly get a place because the commute is so taxing. That's how you do pre-divorce planning in a slow, gradual way. And you're saying, hey, Corey, that takes a lot of time. Yeah, but also a contested divorce takes a lot of time. So sometimes you got to set things up to do things the right way. And if there is bad pre-divorce planning, something sudden, something like they're moving marital money, something going on doesn't feel right, don't give it the benefit of the doubt. That's when you got to call a lawyer. That's when you have to really make sure they're doing the right thing. Let me just give you the takeaway. Status quo, by now, that is so important. That's the snapshot. That is, everything is based on the status quo. And to change the status quo needs to be gradual. Can't be sudden. Gradual, like a good driver in the right lane. That's what you want. You want the judge to see you driving safe on that right lane, not swerving in and out. That's problematic. So remember all this stuff. It could really help you. And if you are a victim of bad pre-divorce planning, where they're trying to move money around, trying to reduce the marital estate, don't wait. That's when you got to really take action. And I know that's going to be hard, but you got to make these fast decisions sometimes. Hope this is helpful. Okay, we're up to stage 2. This is get your bearings. And we're at step 4. This is picking your right attorney. This is your co-pilot. And my metaphor for you is, you got to choose your driving instructor. You got to choose your co-pilot unless you want to do this trip alone. If you do this trip alone, you might get lost. And, you need someone that knows the back roads, knows the highways. And these highways, again, they're going to have tolls and traffic jams. So they got to know how to deal with all that. And you really want someone, I think, at least initially, who could avoid crashes. You're not looking for someone who can just win a drag race. All right, some key terms to think about. You have different service models with attorneys, and we're all probably familiar with full representation. That's traditional, where you have the attorney doing everything. But what's becoming more popular is having maybe starting off with a coach. Let's say you're in mediation and you just want a coach. That's a good place to start. Also, you have what's called limited scope representation, which is if you resolved everything and you just want the attorney to do a specific task, like an uncontested divorce. That's it. Or maybe at the end, you just need the trial and you want to get a trial specialist. That's limited scope. You also want to consider for your guide process fluency. Are they familiar with the out-of-court paradigms? Mediation, collaborative, or do you need someone who's adept in both worlds? That's a cooperative attorney. They like to negotiate, but they can go to court. Or do you really need a hard-nosed, court litigator in more difficult cases? You also want to consider compatibility, not just your own compatibility with your attorney. You want to obviously resonate with this person. You want this person to really feel that they have your back. You feel heard. You feel trusted. That's great. But also, what are they like against your soon-to-be ex? What's that relationship going to be like? And can they stand up to them? Got to be careful there. You also want to consider cost and scope. Currently, what's very traditional is hourly billing, but we're moving to flat fee models in a lot of stuff. Personally, I like to do flat fee for out-of-court work and for trials, but mostly hourly for litigation because it's so hard to predict. Let me give you some hazards ahead, some hazards on the road. If any attorney gives you guarantees, like we're going to get there in 2 hours no matter what, that's not realistic. They don't know what the traffic is going to be like. So be careful if any attorney gives you guarantees. There's no guarantees, especially in litigation. Be careful with vague billing. A lot of attorneys you'll see with multiple associates, this model of double or triple billing. And you have to be careful what they're doing. Are they abusing or is it really for value? You also want to consider if the person you hire only has a one-track mind. So for example, if you hire a litigator, are all their solutions litigation focused? My wife recently went to the doctors and we went to a surgeon, and the surgeon's only advice was surgery. You also have to consider, as I said, a mismatch in your attorney's style and your ex's style, because they may then, you might be too soft or too hard. You also want to be really conscious of switching attorneys, especially once you go to court. Not as important when you're negotiating, except for just increasing costs. But once you go to court and that the judge has some type of relationship with your attorney and they respect them, if the attorney gets out of the case, the judge may feel that you're difficult and you're hard to work with. And even if that's not said, it's going to have implications later on if the case is close. I'm not saying you can't switch attorneys. I'm just saying be careful. Okay, be careful. And the last thing I want to just bring to your attention, especially if you're the non-moneyed spouse, and the non-moneyed spouse generally gets an attorney fee award from the moneyed spouse, but it's not dollar for dollar fee shifting. So if you spend, let's say, $50,000 on attorney fees and you only get $20,000 back, and that's sometimes what happens, you're still on the hook for that extra $30,000. So you have to be careful about that. Let me give you some action steps. And again, you could use AI to help you as a thought partner here before you even talk to an attorney. But a couple things I want you to think about. I want you to test drive a couple of attorneys on these consultations. If the first one really speaks to you and it comes from a great, your friend and it was wonderful, I'm not saying don't hire that person. But if you really don't know attorneys and, you don't really have a good referral, then test drive 2 or 3 and see if one of those 3 makes you feel really comfortable. Not just being a good salesperson, but actually a good attorney. You also want to consider picking what you need. If you're doing a mediation, you might only need coaching. You might not need full representation. And if you really want to try to do this 90-day diplomacy window, you might want to hire a collaborative attorney, at least for 90 days, to try to resolve things outside of court. And if things go south, you might have to switch to either a cooperative attorney who's, versed to go into court, or a litigator. And remember, you want to match that intensity. If your ex is like a sociopath, I'm not saying your attorney has to be a sociopath, but I want to make sure your attorney can deal with someone like that. So some green lights to consider. Does this attorney give you options? That's usually what I hear. Like, if we take this road, this is what happens. If we take this road, this is what happens. If we buy this car, this is what happens. That's a good attorney. Do they listen to you? Listen to your concerns based on your budget, based on your time, your money, your energy? Are they listening to you? Because a lot of times in theory, oh yeah, we can do this, but are you willing to give up, let's say, 4 years to get it? No, then yes, that's how long sometimes these cases take, 4 years. So if you're like, what, 4 years? Yeah, that's what we're talking about. And it's very easy for the attorney to say that. So be careful if there's these guarantees, and also if an attorney just wants conflict. Conflict in my world is just increased cost. You want an attorney who can get out of conflict. That's the best attorneys. Just like, I have an older sister, and when I was younger, we used to fight, and I realized I just can't fight with her. That's smart. Fighting and fighting is not smart. It just escalates. My last summary on this is just when you're getting an attorney, don't consider just horsepower, someone who's like a shark. You're looking for a co-pilot. That's what you want. And you want someone who has a good fit with you, maybe could deal with your soon-to-be ex, very transparent on what they're doing, their strategies. Someone who can settle cases is very important. Someone who can prevent wrecks. Someone who, though they can prevent wrecks, they can also drive that highway. They can negotiate, they can execute, and if you need them, they can go to court and be right by your side advocating for you. Okay, we're up to step 5. This is read your legal dashboard. And my metaphor for you is when you get a new car, you're going to have some new gauges. You don't have to be a mechanic to read these gauges, but you got to get familiar. And I want you to think about 3 gauges, and I want you to think about some warning lights on this legal dashboard. So the first gauge to think about is kids. And kids, the standard for kids is always best interests. And I could say best interest means what you think it means or what a judge thinks it means, because everyone has different opinions. It's very subjective. But I think at the end of the day, it's really about stability, it's really about safety, and it's really about promoting the other parent's relationship, assuming the other parent is a good enough parent. And I say good enough parent, doesn't mean they have to be great, just like you don't have to be a great driver to have a license, you just have to be good enough. Also, there's a distinction between time and decision-making. Decision-making is legal custody. And a parent could have joint custody where everything's decided jointly, and that's usually what happens in marriages, joint custody. But in divorce, a parent could get sole custody. That means they make all the decisions. But don't think you really make all the decisions, because if the other parent post-divorce isn't happy, they can always come back to court. That's why they came up, I think, with split spheres of influence, because parents want to have a say in their children. And even if it's just a say on, let's say, extracurricular activities, that's important, where the other parent may have a final say on education and medical. On parenting time, that becomes a big problem on time, because child support, for whatever reason, is determined by who has more time. And if it's 50-50, the law is basically who makes more pays child support. All right, so it's a little messed up, but basically parenting time, you're looking at overnights. That's how they figure it out. And you're looking at coming up with a formal schedule that's predictable for a standard parenting time. They make exceptions for holidays. A lot of times they just alternate holidays, but you want to define all of this if you can. And if you didn't have a formal parenting plan, obviously before you get divorced, you're going to probably get one in most cases. And that's why status quo really matters, because if things go south and you have to go to court, the court wants to figure out what's been happening. And that's the status quo. That's why that's so important. All right, gauge 2. This is your support. This is your cash flow. This is your fuel for the road. And then start talking about child support. And there's a formula for child support, but the formula only goes up to $183,000. And a lot of parents, especially here in New York, have much more income. And above the $183,000, it's discretion. If in negotiation, it's basically based on lifestyle. If the lifestyle was really high, then it's going to be much more. In court, it's judge's call, just a judge's call. Same thing with spousal maintenance. There's a cap. It goes up to $228,000. And these caps increase every 2 years. Above the cap, it's just discretion, generally based on lifestyle. You could also impute income. You see sometimes that the income is low, the expenses are high. The income only shows $150,000. The expenses show $400,000 a year. How did that happen? So unless there's really a good explanation in negotiation or in court, they can impute income. And last thing to think about in taxes, child support, spousal support, that's not included in income. It's not deductible to the payor. It's like free money to the recipient. It's not taxed, at least on the federal level. All right, the last gauge to think about is property. When I think about property, I don't want you to think this is just 50-50. It's not necessarily 50-50. The court has a statute. It's called equitable distribution. That's what I like matrimonial law. It's pretty easy, right? Equitable distribution means what they think is fair. And there's a lot of factors, but basically they're just trying to define what is fair. But one thing to really consider with this gauge is the difference between marital property and separate property. Marital property is any property that was acquired during the marriage. It's very broad, except for a few exceptions. One big exception would be inheritances. And that's called separate property. Separate property is generally whatever you had before the marriage, appreciation of that separate property. This, of course, if you don't have a prenuptial agreement. If you have a prenuptial agreement, you can change the terms. You can define it the way you want. I'm basing it on the statute. So marital is, if you don't have a prenuptial agreement, is viewed broadly. Separate is viewed narrowly. Now, why this is an issue, if you get, let's say, an inheritance, which is separate property, a narrow exception, but you put that inheritance into a joint account, okay, that could be considered mixed money. It could be called commingled. And then it can turn the character of that separate property into marital money. And the court only has the power to divide marital assets, not separate property. Common items to think about is on the home. A lot of times people make down payments with gifts or separate property. Make sure you have that backup information. If you put $100,000 into the down payment and it came from your account before the marriage, make sure you can trace it. Very important. If you have a divorce with a business, you might need to have experts to value it. Same thing if you have more complicated investments. You might need appraisers to value it, need the marital home to be valued. So experts become very important in property, valuations of property. Some hazards to think about. Let me just go through each gauge. The first gauge on the kids, the biggest hazard there is bad-mouthing the other parent, gatekeeping, where you're restricting access. A lot of parents do that for bad reasons. And also alienation, where you're really trying to get the kids to ruin their relationship with the other parent. I'm not sure why this is done, but divorce is difficult, and smarter people than me have tried to explain this. But if you have anything like gatekeeping, bad-mouthing, attempted alienation, this is serious stuff, and either you got to deal with this therapeutically or got to go to court. On support, you got to look at the lifestyle. That's the most important. If you're in one of these higher income cases, and it doesn't feel that much higher in Manhattan to go over the cap, it's just living. It's just middle class in many areas. But if you're making a lot more money than the cap, and your lifestyle shows that, then that's where the court can really go higher. And if you don't have that income, just remember they can impute income. On property, there's a lot of games with property because marital property is so, large. That term is so large. It's like the I-95. It's just so long. They just want everything to be marital. So you got to be careful of people doing bad pre-divorce planning, where they're making transfers out of the marital estate, where they're playing with title, where they're holding, hiding money, maybe in cryptocurrency. You got to be very careful with all this stuff, and you have to get that information. And we'll get to how we'll deal with that in a later step, but basically it's through disclosure. And just a reminder, the court, and even in negotiation, we're not only looking at a story, we're not looking at a narrative. What we want is documents. We want proof. And that's really what you are looking for in this situation. All right, so some action steps to think about is make a one-page dashboard. This is important because if you can see everything on one page, I think it's really helpful. And have 3 columns, just kids, support, property, one page. And on kids, you want to have just a current schedule. Just a current schedule. That would be helpful. Who handles what? Who goes to school, medical? What's working? What's not working? Just put that on the column. This is just going to be a good frame of reference for you. And again, you can use AI as a thought partner to help you to work through this. On support, just think of if you have the tax returns, the gross incomes, the health insurance, think about childcare, think about add-on expenses, which is in addition to basic child support. You're just trying to get an idea. Add-on expenses could be private school, summer camp, extracurricular activities. You're just trying to get a cash flow idea. What's the cost of the home? Put that in the support column. And on property, you just want to put what are the major assets that you think need valuation, maybe experts, or just are going to be problems. And if there's debts too, put that on the property. I think that's a very good place to have the dashboard. And also, you want to consider non-negotiables and your nice-to-haves. This is where you're trying to protect your energy, where you're trying to protect your budget. This is why if you have non-negotiables, someone kidnapped your kid, that's a non-negotiable to get your kid back. But if you're fighting the difference between $1,000 here or there on support, that might be a nice to have. That's not a non-negotiable, and you don't want to spend years and over budget just to fight something which may be meaningless at the end of the day. You also, as I said, and I'm really harping on this, you got to gather proof. You need the last 3 years of all those tax returns, all those schedules, W-2, 1099s, K-1s, whatever they have included, even some of these large tax returns. You want bank statements, credit cards. You're looking for lifestyle. You want the investment accounts, the retirement accounts. Get this financial picture. And if you have the children, have a calendar, have the doctors, have the dentist, have all that information, all the activities in one place. And if you're in a case with higher income, just remember, there's so much discretion. There's so much discretion. And that's why you have to behave a certain way in court. I think you got to behave a certain way in court anyway. But when you give the court discretion, when the court has discretion, you have to behave, because at the end of the day, the judge is a human, and they may, in closer cases, just rule in favor of the one they like more. Okay, remember that. In summary, you got to know which gauge runs hot. And you got to think kids first. That's your main gauge. Kids first. Give those kids good childhood memories. That's your goal as a parent. On the support, you're looking for predictable cash flow. Can you pay for your lifestyle? And that's really important. And on property, remember, it's not always equal. In longer marriages, especially if there's children, it's going to be equal. But in shorter marriages, no children, it might not be equal. And lastly, above all, please, not just your feelings, not just a narrative. You got to back it up with facts, with proof. That's what you need to really be persuasive. Okay, we're up to step 6. This is discovery and financial disclosure. This is getting the facts so you can settle smart or prove your case in court. My analogy here is this is the pre-trip inspection. This is popping the hood. This is checking for fluids. This is confirming the route. We're not guessing here. We're verifying things. And let me give you some key terms to think about. There's 2 types of discovery, which is information gathering. There's informal discovery, which is a voluntary exchange of information. That's what you're going to see in the collaborative side, out-of-court side of things. And then there's formal discovery, where people are playing games. They don't want to give you the information. And some court-backed tools to think about, and this is generally through an attorney, is what we call a D&I, or discovery and inspection, which is a document demand. You can put subpoenas to your attorney on banks, on credit cards, and other third parties to get information. You can take a deposition, which is a out-of-court, basically testimony. It's as if they're in court, but it's out of court with a reporter. They're sworn. You can ask them questions. You can ask them follow-up questions. It's either done in person or virtually. That's really important in deposition in more complicated cases. And also you have what's called interrogatories, which aren't as effective because they're written questions. You can get answers, but there's no follow-up answers, and it's written. Deposition, real time in person. And the biggest disclosure you're going to get is in your divorce is called a statement of net worth, an SNW, statement of net worth. This is a snapshot of your income, your expenses, your assets, your debts. It's everything. And also your transfers in the last 3 years. Take your time on this. This is the most important document you're going to fill out. And it is annoying to fill out. You could use your accountant You can use your attorney. You can use the paralegal. You can get help. But make this document, take time on this document, because if there's mistakes, it goes to your credibility, and you got to be careful because all you have sometimes is your credibility. You want to have that paper trail. You want to have the last 3 years of all of your bank statements, your credit card statements, your income taxes, your investments, your retirement accounts. If you have any loans, all that paper trail for the last 3 years. That's the type of disclosure we're talking about at a minimum. Also, I want you to consider the 90% rule. I've seen people in discovery get bogged down. They want every little piece of information, and I can appreciate that. It's a difficult time getting divorced. It's scary, and there's a lot of fear, and you might really feel you need everything to decide. But I think if you have at least 90% of what you think you need, you can start negotiating. I'm not saying you have to settle fully, but you can start negotiating, and you can make it subject to getting additional information. Experts. Sometimes you need experts. Sometimes you need experts to value assets, a home, a business. Other times you need experts to do forensic analysis on if there's cash flow issues, if there's underreporting, stuff like that. You could also use experts on the child side, but we're really focused on financial disclosure here in this step. Some hazards to think about. In the informal discovery, if you're doing a 90-day window, what I see is you say, okay, we'll exchange all this information within 30 days or 45 days. And then 45 days comes around and you don't get anything. So what do? You might ask for one, follow-up, give them a 2-week adjournment to produce the documents. But if they don't produce the documents, that's where you might have to move to more formal measures. That's what I mean when I talk about a collaborative attorney who tries out diplomacy, 90-day window, but then goes to court. If you just did a collaborative attorney and they don't want to produce the information, you're going to have to switch attorneys and then maybe go to court. It makes it a little bit more difficult. Also, you want to consider people who hide information, and you're going to see this, or who are selective in what they produce. You have to be careful on this. It could be inadvertent, but they also might be trying to cover up things. You also want to consider a cost-benefit analysis. A lot of times, why I'm big on this 90% rule is you may be spending $10 to get back $1. So don't try to throw good money after bad or good time after bad. You got to be careful sometimes. Let me give you some action steps. Get those documents. Get at least the last 3 years of all the information I talked about, the tax returns, the income statements, the credit cards, the retirement accounts, the investments, all that locked down. Complete that statement of net worth, that SNW. Do it carefully. I go through many drafts in the statement of net worth. It takes time. It's annoying, but you have to do it properly. Most important thing. Try to exchange documents informally within 90 days if you can. I always try to do diplomacy before war unless there's an emergency. And think of information that's must-have, like income, assets with nice to know. Because sometimes you can't prove things in court, unfortunately. And that's why the 90% rule is so important. And then use neutral experts if you can. You and your spouse can share experts. Even out of court, you can share experts. And that's why it's so helpful to move things forward. So in summary, I said it before, you got to just make sure you have the facts. You have the backup documentation. And that's what discovery is so important. It's about getting that backup documentation. And start cooperative. You're going to have to produce documents anyway. There's so much fight over getting documents. Don't play these games. Produce the documents. I know what you're going to say. If they don't produce it, still produce it. Because if you're in court and the court sees you're producing, you're acting appropriately, and the other side's not, again, at the end of the day, the judge may remember this. And if it's close, they may rule in your favor for someone who's acted out. And the court, if someone really acts out, they could issue an adverse inference against this other spouse who's not producing the required documents, and things can go in your favor. So you always have to behave appropriately in court. And remember that 90% rule. Maybe you only need 90% of the documents before you start negotiating. And you can always finish getting the additional information subject to verification once you guys agree on a number, which can always change. So for example, if you're dealing with income and you say, okay, I want this child support based on next year's tax returns and they're coming out in a month, and if there's a big difference, then you can always change it. But if the numbers are about the same, then you can keep it. And be honest, be fair, be organized in this disclosure. And I think that really helps you come from power. I know this is going to be a little scary to do this if the other side's acting out, but act civilly. It kind of reminds me on the highway, just because people are driving 85 miles an hour on a 55 mile an hour road, that doesn't mean you need to. Okay? Maybe 5 miles over the speed limit, and that's it. That builds your credibility in negotiations and in court. All right, we're up to stage 3. This is move forward. And we're up to step 7, which is negotiate and draft the deal. And in my road trip analogy, I want you to think of the difference between local roads, which is settlement, and highways. And local roads, it's a little bit more flexible, a little bit more creative, it's private. Highways, structured, rigid, there can be tolls, and it can be congested. So let me give you some key terms to help you think about this in a different way. First of all, these two roads run parallel. Okay, they're not separate worlds. You got the settlement track. That's where you can do it informally. You can go to mediation. You can go to collaborative. It's all about settlement. Even when you're in court, you have settlement time talks. But then you have the court track. And the court track pushes people forward. Remember, 95% of cases settle. So think about these two tracks. The biggest thing I want you to take away from this idea in negotiation is anchoring. And if you haven't heard the term anchoring before, this is how you really negotiate at a higher level. Because negotiation is really a psychological dance. I didn't think it was a psychological dance. I used to think you can just say to people what you want, but we like deals. If you're buying a car, there's an MSRP, but then you like to negotiate. And so what you have to do is you have to frame what you want and then give concessions, and that's the dance. So for example, if you're asking for, you only want $2,000 a month in child support. You don't just say $2,000. You might say $3,000, right? Because then you have the other side has the opportunity to negotiate you down. So you can do anchoring on everything. You can also anchor parenting time. Let's say you want 4 weeks in the summer. Don't start with 4 weeks. Start with 6 weeks and then try to anchor down. That's the idea. Another thing I want you to think about is take the major issues in your divorce in stages. Okay, so there's 3 main ideas or segments. The first segment is kids, then support, and then property division. And take that in stages. I think it's very helpful. And then you can also lock in agreements with partial stipulations or partial agreements. So if you can resolve the children issues, enter into a parenting plan. Literally execute it, formalize it. Then you have an agreement on that issue. No way to get out of it. You secured that win and move forward. And when there's problems, when you negotiate, you don't only have to go to court. You can call in these neutrals, these child specialists, these financial appraisers. These people help you move forward. Now, let me give you some hazards ahead. There's always roadblocks on the road. So here's some hazards, 3 hazards in particular, 3 big ones. You have position polarization. Okay. That's where you get so stuck with what you want, you lose sight of the bigger picture. Okay. That's like saying on custody, 50-50 or nothing. My way or the highway. The problem is, let's say you do want 50-50 or nothing, but that may not be appropriate. Maybe you work 100 hours a week. Maybe you don't even live in the same state. So this is why you need to bring in these neutrals to help you. Generally, it's you move your position. Don't get stuck in position polarization. Another thing I see in settlements is drifting. One thing good about the court is it moves things forward. They have deadlines. Court pushes you. But if you're outside of court and you can do what you want, you could just drift. In law school, they only had one test. That's only one test. It's not if you missed the time in college or maybe even high school, there was multiple tests because you could be drifting for all that time. You could also have a problem of over-negotiating. Over-negotiating could be a big problem. That's where you're trying to win everything. I had this case early in my career against this high-end attorney, and he was so good, so classy, and at the end of the day, he got exactly what his client wanted mostly, except he gave me some relief on some issues. No reason he had to do that. That was just to settle the deal, to make it easier for my client to accept it. And I think that's really how you have to practice. You can't over-negotiate. All right, so let me give you an action plan. Let me give you 5 steps to think about. First, choose that starting lane. Ideally, settlement, unless there's some emergency issues. Second, set those anchors early. The earlier, the better. You got to frame that negotiation. Third, work in segments. Deal with the kids, deal with support, deal with property. If you could only resolve kids before you go to court, that's a win. That's a major win. And add those neutrals in, those neutral experts. If you need help, if you're having problems with a child plan, can't figure out a parenting plan, bring in a child specialist. You can't figure out cash flow, you're fighting on child support and maintenance, bring in a financial advisor. You can't figure out the price, the value of a business, you can have a financial appraiser. All this stuff can happen. And then finally, be ready to reroute. My wife loves updating those updates on Google Maps where you're driving on the highway and it says, oh, if you go off this exit, you can save 10 minutes. I don't necessarily like doing that, but sometimes it is better to reroute than just staying in the same lane. All right, so in summary, negotiation, it's wonderful, but it also can be challenging because you got to play the game. You got to anchor. You got to have a dance. It's not a straight line. And I want you to realize that with these tools, you're not just a passenger. You're not just a passenger. What you do, your behavior is going to have impact, and hopefully it's going to make it easier for you to negotiate in a better way. Okay, we're up to step 8, which is divorce emergencies. In my road trip analogy, this is where the hazards lights come on. Next thing you know, you're pulling that car over onto the soldier. You need a tow truck. That's what the emergency application is all about. You need a legal tow truck. You need some help. Let me give you some key terms to think about. First of all, what's an emergency application? That's where, you maybe you're trying to negotiate, trying to move forward, but something is happening that you have to stabilize. It could be a support issue. They cut off all your support. It could be a children issue. There could be trying to abscond with the child. It could be domestic violence. Something is a problem. And that's when you need an emergency application. And let me decode some language, because in court, we like to use some language that I want you to be familiar with. These emergency applications, we call them order to show causes, which we abbreviate OSC. So if you hear order to show cause, OSC, these are just emergency applications, okay? And this is think of it like a fast track to get to the judge. You're also going to hear pendente lite relief. That's just interim relief. A lot of these emergency applications, or most of them, are only for requests made pending the divorce, not post-divorce. So again, if you want temporary child support, you want a temporary parenting plan, that's where you make these applications. And the court's not going to do a final parenting plan, a final support order. That would be after trial. Also, you're going to hear the term ex parte, which just means one-sided. Can't just reach out to the court without giving the other side notice. You can't also do that with neutral experts. If both of you retain experts, you can't have ex parte communication. Can't be one-sided. All right, so let me give you some information about which court to choose. There's 2 main courts in our family world. There's the family court and the Supreme Court. Now, you would think the family court handles everything, but no, it does not. The family court handles everything except divorce. So you can have orders of protection, that's family offense issues. You could have child support. You could have spousal support. That's what family court deals with generally. In the Supreme Court, they deal with the divorce. So they can deal with all those other issues as well, family offense, child support, custody, but they also deal with divorce, deal with dividing property. So you got to choose your courtroom. And one thing you have to understand is family court's set up for self-represented people. Attorneys can go there, but it's a lot more informal. And in Supreme Court, it's really set up for attorneys, so it's much more informal, much more expensive to do it generally in Supreme Court. Also, you want to consider the part rules with your attorney. Each judge, this is more so in Supreme Court, they're very busy, especially in New York City. And they came up with these part rules, their own rules, where you could email the court sometimes if you're having an emergency, and they might grant a conference just to discuss with you the issues, maybe a virtual conference, just to see if you can resolve your emergency issue before making an application, because the court, again, is burdened, and also it's very expensive. And that's something to think about. All right, so let me give you some hazards ahead. Not every crisis that you're having is perceived by the court to be a crisis, to be an emergency. They decide. It's like I went to, the hospital earlier on in my career with a client who had some facial scarring, and we had to wait for hours. And finally, when we got back there, we saw this person that was like half burned. And that's what they're dealing with. So the court might be dealing with some serious problems. So not every crisis is considered an emergency for the court. So don't think just because you file something, the court's going to sign it that day. They may take some time. Also, you want to, and this is taking the high road, especially if you have children, and you're not going to see this done. This is countercultural idea, but avoid the emotional attacks to the extent you can. This divorce is going to end. Even if it ends in a few years, it's going to end. But you're always going to be co-parents, no matter if you're parallel parenting or not. Parallel parenting is you're really just doing your own things. And, how you act in your divorce has future repercussions. So be careful on these emotional attacks, especially if you have children. If you don't have kids, I'm more liberal on that. Do what you want. Okay. Also, you got to back up your claims. Back up your claims with evidence and documents. It's not just making allegations. You got to back it up. So if you say the other person makes $150,000, the court wants to see, a W-2, a tax return. That's what the court's looking for. All right, so let me give you some action steps, and I'll give you some 3 key action steps here. So the first, check the court rules with your attorney. Maybe, and a good attorney would know this, maybe you can make an email application to save you some time, money, and energy. Second, I want you to create a timeline. This is so important, because you're going to have so much information, and you are the master of the facts. But the more you can synthesize this information in an easy master document that is searchable, that is, coherent, that is unified. So, and it's going to evolve, this timeline. So you want to put the key dates, you want to put everything you can think about in this timeline. And this is going to be a great roadmap, especially later in your divorce, if things really get serious where you have to do a deposition or a trial. So create that timeline. Also, gather the evidence. We call these exhibits, but make sure you have the documents that you need to prove your case if you can. A lot of times they're emails or texts, but they can be more than that. Also, you might need an affidavit from a third party who's witnessed what you're asking the court to deal with. The court's looking for, some type of additional evidence to corroborate your claims. So in summary, the big thing about emergency applications is getting organized, make it easy for the court to rule in your favor, and see if it really is an emergency or just a crisis for you. If it's only a crisis for you, maybe an email to the court to see if they'll establish a conference to save you time, energy, and money. But if it's a true emergency and you got to hit that panic button, file that emergency application. All right, we're up to step 9. This is our last step, and this is the preliminary conference. This is your checkpoint. Before you get to merge back onto the main road of your life, which I know you want to do, I know you really want to do that, and things haven't settled, and you got to push this case forward, you got to go to court. And the first court conference is called the preliminary conference. We call the preliminary conference the PC. It's not a trial. It's just a conference, not a hearing. There's no testimony. It's just a conference. And you have to approach this in a very structured, organized way. So let me just go through a couple things to think about. First of all, let me tell you about the essential documents. You have the preliminary conference order, which is the PC order. This is the most important document from the court's perspective for scheduling of your case. That's going to have what issues are resolved, what issues are not resolved, basic information about your case. It's going to talk about your discovery plan, when documents are due. It's going to see if you need experts, if there's future conferences. There's going to be all that in the preliminary conference order. And that's very important that you're going to review with your attorney. And then from your perspective, and listen up to this is so important. The most important document from your perspective is the statement of net worth. And both of these, the PC order and the statement of net worth, they're in the exhibits, and I have additional videos just to go through it so you can see what it is. But for here, the statement of net worth is basically your financial transparency. It's your monthly expenses. It's your income. You put down your assets, your liabilities, all this information in one place. And this is the starting place of negotiating. And so you should really take a lot of time. So let me give you some hazards to think about. First of all, spend time on this statement of net worth. And I know it's hard, especially if you're overwhelmed, but spend time on it and reach out to help if you need it. Okay. So this is not a fun experience, but you need to do it and do a few drafts to get it really good, because your credibility could be shot if you omit assets or understate your income. So make sure it's accurate as possible. Second idea is, at this preliminary conference, you could ask the judge. This is in more cooperative cases for the judge's opinion. Now, it's not binding, but sometimes you just need a decider. And in those cases, it's great to ask for the judge's opinion. So let's say, for example, you're trying to figure out support. You know the income. You know the expenses. You know what you want. You know what they want. You could ask the judge, hey, based on this information today, hearing what you're hearing, what do you think is the right move? And they may give you an informal opinion. But here's the trap. If you don't want to accept that opinion, it may hurt you later on, because the court now gave you their opinion, and now you have a higher burden to try to prove them wrong. All right, let me give you some courtroom etiquette ideas. You need to treat this court, the judge, with super respect. So for one thing you got to do is you got to get to court, especially if it's in person, an hour before court, especially your first time. You got to go through security. You might get lost. There might be traffic. Get there early and bring snacks, bring water. And you're going to get there and it's like going to the airport. You want to get there early. You don't want to be stressed. It's stressful enough. If it's on virtual, log on 10 minutes before. You could update. For some reason, the court now uses MS Teams. Every time I go on MS Teams, it has to update, because who uses MS Teams? No one does, but the court does. So log on 10 minutes early. Make sure you can log on. Make sure there's not going to be any problems. Also, you can't record any of these conferences. You can't record it in person. Easier to record it virtually. Can't do that. Against the rules. So be careful. And why am I telling you this? The hazards here is you can burn your credibility. You can burn your credibility. And I'm not saying the judge is going to, rule against you just because you burned your credibility, but in these closer calls, they may. So let me give you some action steps. You heard it from me. We start early with that statement of net worth. That's the most important document. When you request a conference, it could take a month. It could take 2 months before getting a date. In that time period, you are preparing your statement of net worth. Okay. You also need to draft with your attorney. You got to review it, that proposed PC order, the preliminary conference order, see what issues are resolved, what's unresolved, your discovery plan. You're putting that down. And the judge isn't putting that down. You guys are. And you work with your attorney to do that. Also, I want you to understand, just, anytime you go to court, the ratio is at least 3 hours of preparation for 1 hour of in-court time. So that's the ratio, 3-to-1 at least. Maybe in trials, it's 4-to-1. And what's the payoff here? If you have a close call, the judge is only human, and you've been respectful, you built your credibility, and the other person hasn't. What do you think the court's going to do? Now, a lot of times what I get is, hey, Corey, we're trying to be above board, but the other side is being aggressive and they're not doing anything. The judge is remembering. But it takes years for a trial, at least here in New York City, to be scheduled. But they're like elephants. They have long memories of what's going to happen. So in my experience, there will be a payoff, but unfortunately, it could be years later. So be respectful, be prepared. All right, here's my summary for you. The preliminary conference is, the start of the court process. And I hope you only have one conference before the court. But if not, everything starts from here. You got that PC order, you filed that statement of net worth, and you got to take it really seriously because this is the start of getting the court to maybe make a decision on your behalf, which I hope doesn't happen, but sometimes you do need that to happen. And if you are going to have the court make a decision, do everything you can to put yourself in the best place possible. All right, we're up to our final thoughts. Well done. You just traveled the map from driveway to the first court checkpoint. And here's a summary of the journey you just took. Step 1, that was that driveway decision. That's, am I doing this divorce thing? Step 2, this was choosing your route. Am I doing some of those non-court approaches like mediation, negotiation, or do I have to go to court? We talked about that in step 2. Step 3, this was prep your car. This is that pre-divorce planning. This is that protecting the status quo. Step 4, choose your guide. You have to find that right attorney fit. Step 5, read the dashboard. Those are those 3 gauges. That's kid, support, property. Step 6, check under the hood. That's your discovery. That's your disclosure. That's where we roll up our sleeves and find out what's really going on. And step 7, that's the difference between the local roads, which are settlement, a little bit more custom, versus the highway, much more structure, but there could be a lot of traffic and a lot of tolls. And step 8, that's the emergency off-ramp. That's where we have to bring in the court. Something happened, but it has to be a true crisis. And step 9, that's the court checkpoint. That's the first conference with the court if your case doesn't settle, the preliminary conference. Now let's just zoom out, to a little bigger map of your life. And this isn't just about legal strategy. It's about how you show up moving forward. And the way you handle your divorce is really the way you handle your life. And divorce doesn't end. Co-parenting, finances, these choices continue. And you're not driving alone. Your kids, family, community, they're all in the car with you. So let me give you some next steps. First, you don't have to do this alone. You could use the tools, you can revisit this guide, you can talk to some experts, you can DIY it if you want, or a combination of the 2 or 3. But if you're feeling pushed around, you're overwhelmed, you're stressed, and you tried everything, and you're just scared, you can always schedule a free introduction call with me, and we can see if we are a good fit. So I want to thank you. I want to thank you because now you have a roadmap. So you can move forward with clarity and strength. And thank you for completing this journey. Thank you for trusting me to walk you through it. And my goal was not to make divorce easy, but to make it clearer, calmer, and more manageable.